Not at all.
Welcome back, everybody. Aaron Keller along with you for the afternoon hours here, along with Ken Belkin in studio and Jessica Jackson Sloan joining us from California via Skype today. I'll throw a question on the table that's been burning my mind up as I watched the notes from this morning. We ultimately have competing doctors on the stand being called by the prosecution, and they are all ultimately giving different diagnoses of this defendant. How does the jury even try to sort through this mess? Jessica, I'll start with you.
Yes, well, first, thanks for having me on. So like you said, there are competing experts saying different things. You've got Kelly saying that even though, and Kelly is a credible witness, I think, with the jury because he has testified in so many cases on behalf of the prosecutor, but saying that, there's no way that Loya could have actually appreciated the nature of the consequences of his action, conformed to the law in this case, and that is a very heavy statement to make to a jury. So the jury's just going to have to do a witness credibility weighing. They're going to have to decide who they trust more and who's coming across as more credible.
So Ken, if you're forcing the jury to do that, then what's the best way to go about it?
Well, first of all, to Jessica's point, look. The fact that that Dr. Kelly made that statement, that it was a legally conclusive statement and really should have been objected to and been inadmissible. But who's going to object to it?
Is
the defense going to object that? Are they going to object to that statement? No, they want the jury to hear that. And the prosecution, they're too busy thinking what their next question that they're going to ask is going to be to object. But look, I think it's pretty common knowledge of what Asperger's and autism is. And I don't think you're going to convince any juror that someone who suffers from Asperger's or is on the autism spectrum, someone who is high functioning, which Dr. Kelly also said, is going to be unable to discern between right and wrong and to conform their actions to the color of the law. It just seems laughable.
Well, we've got that two-pronged statement that you just brought up, Ken, and that ultimately is how a defendant can issue this defense in Massachusetts. They either have to not be able to appreciate what the law requires, or they have to, for some reason, by way of mental disease or defect, not be able to follow it even if they understand it. And what the really difficult witness for the prosecution said, the first one, Dr. Kelly, he said, well, he understood right from wrong, but he just couldn't conform to it because he was so fixated on this sense that he needed to inject justice into the situation. Now, that really shoehorned the defense into one of the two either-or prongs on the model jury instruction in Massachusetts and the way that they make the jury look at this issue. So they need to be able to get up there at this point and say, well, he knew right from wrong, but he just couldn't conform to it. And I tend to agree with you, Ken. I don't know if people are going to look and say, gee, from what we're hearing from all these experts, the bulk weight of the testimony at this point is that he could probably have conformed.
I mean, to say that this guy can't conform his actions, this is a guy who went to the extent of planting a gun at the scene, setting incendiary devices, setting his car on fire, attaching a GoPro, getting the tactical gear in place to wear. This guy went to meticulous planning. He certainly does not have any impulse control problems.
Jessica, I'm wondering what you think, because the bulk weight of us sitting around the table here have come down on the side that this defendant should probably be found guilty, but Elora Nanos and I were really going back and forth on it yesterday, and she was hedging a little bit on it. What do you think?
Listen, I think those are all difficult facts for the defense to deal with, but really, Loya has said that he sees himself as a tragic hero who's righting a monstrous wrong in a battle between good and evil. These are facts that actually support those statements. He's trying to set his car on fire. He's written this 250-page manifesto. He's become sort of obsessed with this woman based on, various incidents that happened and relationship that happened, but to the point where he's talking about the way that her scent makes him feel and really kind of become delusional about her. So he's got this delusion that he's sort of in the midst of this battle of right and wrong. And I think that the jury is going to see a lot of these really bad facts actually fit into that delusion and support the fact that he is having a mental break there.
Well, what do you make of this first doctor who was on the stand, Jessica, who said, oh, yeah, he wrote about the excitement he felt when he smelled his victim's scent and back when they were in Alaska. And it was the best day of his life when he had some interaction with her and all of this other stuff. But then the same doctor said, oh, I don't think that that's romantic interest at all. To me, that just sucked the credibility out of 99% of what the doctor said on the stand.
Well, it depends if it's romantic or not. Is it delusional? Was he actually sort of characterizing these encounters as something they weren't in his head? In which case it actually supports the fact that he was having a delusion and was not able to conduct himself in a way that conforms with the law.
Yeah, so I'm still trying to figure out whether or not the jury is going to buy that whole thing. So it seems to me that one rational way to look at it is to just look and say, hey, look, Doc, I don't believe your assessment in that case, and I can write off your assessment that he was somehow not criminally responsible. And that deals with the first doctor. Then you've got all the successive doctors on the stand who presumably had, I didn't get to see all of it this morning on my way in, but who presumably were able to give more credible testimony. So I'm wondering, and maybe Ken, you can jump in on this, could the jury look at it that way, or did some of the other doctors not fare terribly well on the stand?
I think there's a big elephant in the room. First of all these experts, how much time could they possibly have spent with him? Not that much, They did their preliminary diagnosis of him in a really abbreviated time period. And there were several doctors that have reached diagnoses. So you can imagine that the time each one spent with them was limited by the fact that he was meeting with other doctors. Now, the elephant in the room in my mind is, do people with Asperger's and autism, if that's the most severe mental health diagnosis that he has, look, I'm not trying to minimize these illnesses. They're horrible for the people who are afflicted by them. But are they so severe that the person that's feeling them is so out of touch with the reality that they can't appreciate the difference between right and wrong and recognize that taking another human life is wrong? I don't think so. And I don't think a jury is going to think so either.
Jessica, I'm wondering if the prosecution really needs to get an expert in these particular alleged diagnoses on the stand to try to clear the air about this.
Yeah, I think that they should. I think that it will help the jury to be able to come up with, their analysis and really their credibility. We use the terms autism, Asperger's. Those are colloquially used, as well as there is a medical definition and diagnosis for them. So people who are on a jury aren't experts in the medical field. They're not psychiatrists necessarily. I realize that these psychiatrists did spend limited time with him. I believe Dr. Kelly testified to spending 9 hours with him, which certainly is not a lot of time, but also reviewed the record, reviewed statements that had been made, etc. So the jury is going to be reviewing the diagnoses that have been put out there, reviewing the evidence, obviously, and coming up with a credibility determination for the various experts to figure out which one they believe.
It's funny, 9 hours. That's like a first, maybe second date. How well do you know someone by a second date?
Well, if it goes well, maybe. If it doesn't go well, then I'd just be like, see you later.
But even still, even if it's a second date, 9 hours, how well do you know someone on the second date? Not very well.
Please hold the camera shot on Ken Belkin so he can react to his own statement, because I'm not going to go there. So, point taken, though, that, look, these people are professionals. They're supposed to be giving an assessment. I guess they're trying to call it the way they see it, so maybe they need 9 hours. Maybe they should have more time. Maybe that leaves them more open to a defense attack. And I know the defense did attack at least one of the doctors a little bit about that. It leaves them open to a defense argument on closing that, hey, look, they should have spent more time with him. But then we've got this other issue, and we're waiting for them to come back from lunch in just a second, but we've got this other issue about what was going on in the Coast Guard, because the defendant won't let anybody get access to what was going on in the Coast Guard. They couldn't review his Coast Guard records, and I know that it's really, really hard for state-level prosecutors to get a hold of federal service records of this type. I've been trying to do a little side homework on that, but ultimately, that's a big question mark, and we might not get that answered. Jessica, your thoughts?
Yeah, so there are documents. This occurred in 2015. They should be able to get those documents. Hopefully, I'm not sure how hard it is to get service records, but it seems to me it'd be something that the defense would be able to get and hopefully try and get and find anything that might back up their theory, since the files do belong to their client and they are records pertaining to him. Hopefully, they'll be able to get it and look through them and find something to support prior delusions or any other strange acts.
Now, I know that this is a somewhat novel question that many of us are not faced with on a daily basis, but Ken, can you think of any evidence issues that even if the records existed would prevent them from coming in?
I mean, national security, but I don't know that really national security is going to play a part in this Coast Guard human resources records.
Right.
But, look, this case is really tough for the defense. If he had a more serious mental illness like schizophrenia or bipolar, they'd at least have a shot with this defense. This is not the most serious mental illness, not to disparage anyone that has it and is afflicted by it, but it's not so serious that I think a jury is going to believe that Mr. Loya could not appreciate the difference between right and wrong. I just don't see it here. And by the way, even in cases where the mental illness is much more serious and the delusions are much more apparent, the jurors are not apt to believe it. They frequently convict defendants who try to mount this defense.
And we have the other issue of the burden being on the prosecution of proving he was sane, and that's different than the way many other states do this.
Yeah.
We're seeing the defendant being brought into court, so they're going to get going in just a second here. Jessica, what do you think the defense needs to do to try to clinch this at this point?
Listen, at this point, I would keep coming back to the facts that stand out as clear signs that there is mental illness. His obsession with Lisa, his well-documented manifesto called Loya Wars, his belief that he's in this battle between good and evil, his preoccupation with their encounters, even the fact that, he put a camera on himself and had this idea of how the police were going to be busting down the door and ready to shoot him for the police suicide portion of his plan. I think the defense needs to keep coming back to all the different facts that actually support the fact that he was going on a delusion here in this case.
Wait a second. He called his manuscript Loya Wars?
Yes.
Yeah.
The defense better read that whole manuscript to the jury, because that's probably going to be the best shot that they have here.
I'm waiting for it because nobody's seen
Waiting
a copy
for it
of it yet.
in paperback, I assume.
Well, it's one of these things where it may be another one of these exhibits that the judge allows the jury to look at in the jury room, but it doesn't get read into the record. The judge has put a lot of restrictions on what we can and can't see in this case, which, in my opinion, goes against the grain of the bulk of the case law. If an exhibit is offered, then generally it's public. And the judge is saying, well, yeah, it's public, you can come and look at it, but you can't disseminate it. Well, that gets tricky for those of us sitting around the table because we can't look at any of these things. So it exists, and there are other files as well, and the jury's been back and forth with that.
The defense attorneys better go through that manuscript with a magnifying glass and pick out the craziest parts and make sure that those are read to the jury.
It looks like they're coming back into session. Jessica, I know you need to run. Thanks a lot for joining us. Mayor of a place in California, Mill Valley, right?
Yes, yes.
Okay, and attorney as well, so good to see you here on LawNewz.
Good to see you too.